Assalamualaikum and a very good day to our lecturer Dr. Suhaimi and our fellow classmates. In this video, we will be discussing on our chosen case study. Let's get started. But first, let's meet the team. I'm Nurul Izzati binti Muhammad Arapa and these are my teammates Muhammad Ridwan bin Taufik, Siti Khadijah binti Muhammad Yusof, Raja Nabilah binti Raja Muhammad Khairuddin, Norafina binti Azlan and Sabaria binti Seth. Let's start with our first presenter.
To answer the first question, Employment Act 1955 is an act that protects the right of all employment in Malaysia. All employees in Malaysia are protected from unfair termination, and pursuant to Section 20 Subsection 1 of the Industrial Relations Act 1967, employers must ensure that the employee is fired in a fair and legal way. An employee can only be terminated for just cause or excuse. Although the Act does not specify just cause or excuse, the reasonable reason for dismissal include excessive employee misconduct, redundancy, poor performance, and negligence. However, according to the Employment Act 1955, there are rights and protection being outlined to the employees with respect to their termination and layoff. The first benefit provided within 60 days of being fired, an employee can submit a complaint with the Director General of Industrial Relations. The Industrial Relations Department will then set up a meeting between the company and the employee to try to reach an agreement. At the meeting, an Industrial Relations officer will serve as a mediator. If he can achieve an agreement, a contract will be written up outlining the details of the agreement and the case will be considered resolved. The employee must speak for him or herself or may be represented by a trade union officer.
So let's continue with the second and third benefit of employment termination and layoff. So the second benefit is employment termination or layoff 1918 regulation provide retrenchment benefit to EA workers. The 1980 regulation apply only when employees are terminated for reason other than retirement, misconduct or their own desire. Section 667 Employment Act 95 severance pay that an employee is entitled to upon termination, the sum matches directly to each employee's length of service. Refusal to comply with the 1980 regulation will be an offence. The Malaysian retrenchment benefit for EA eligible employees are as follows. Employees who had served the firm less than 2 years will entitled to get 10 pays for each year of their employment under a constitution contract of service. Meanwhile, employees who served the first more than 2 years but less than 5 years are entitled to get 15 days pay for each year employment. And lastly, employees for 5 years or more was entitled for 20 earning for each years of employment. So let's move to the third benefit is employees are protected in circumstances of unexpected termination as the industrial court has primarily relied on the code of conduct for industrial harmony. So code of conduct in discussing cases of wrongful termination, it enhances job security by encouraging business to offer retirement, retrenchment and sick pay plans in addition to current legislative measures.
All in all, Malaysia Labour Law established a framework that protects both employers and employees for unfair practices. It acknowledges the employee's right and privilege to make choices in the best interest of the company. At the same time, it preserves employees from a wrongful dismissal.
Next, I will be discussing on question 2 whether Mr. Bala has contravened any provision of the Employment Act 1955 when he terminated the services of Haris and Siva and replaced them with Indonesian workers. So based on the above case, Mr. Bala has contravened the provision of the Employment Act 1955 under Section 60M prohibition on termination of local for foreign employees, which clearly stated that no employer may terminate a local employee's contract of service in order to hire foreign workers. In the case study, Mr. Bala decided to terminate 50 employees including Haris and Siva and replace them with Indonesian workers, which he can pay half of the rate of Malaysian workers. This clearly violates the Act under Section 60M, which Mr. Bala should not have done that to the Malaysian workers. In instance, Mr. Bala shall be fined according to Section 99A of the Employment Act 1955. It provides that any person who commits an offence or violates any provision of the Employees Act or any regulation made thereunder for which no penalty is provided shall be fined not more than Rm 10,000 on conviction. That's all from me. Thank you.
I'm Nabila. Will explain question number 3 together with Sabaria. Starting from 1st January 2018, the coverage for foreign workers are under Employees Social Security Act. Employers who hire foreign workers shall register their employees with Social Security Organisation (SOCSO) and contribute to the Employment Injury EI scheme under the Employees Social Security Act 1969, subsection Act 4. Thus, all legal foreign workers will be protected under the Act. All the laws applicable to employees in Malaysia are equally applicable to foreign workers as well. There are several protections available for Indonesian workers. The EI scheme provides protection to an employee against accident or an occupational disease arising out of and in the course of his employment, as well as communicating accidents. The EI scheme consists of medical benefits, temporary disablement benefit, dependence benefit, permanent disablement benefit, constant attendant allowance, funeral benefit, and rehabilitation benefit. But we only explain two, which are medical benefit and temporary disablement benefit. All foreign workers must be covered by medical insurance beginning January 1st, 2011. The Foreign Worker Hospitalization and Surgical Scheme is one of the medical benefit covers each foreign worker and medical treatment and hospitalization at government hospital up to 10,000 ringgit. Medical benefits would be charged as the same rate as third class accommodation and board, up to 60 ringgit per day, with plans covered accident, illnesses, and injuries. Lastly, the foreign worker, which is an Indonesian employee, is responsible for the annual premium, which costs 120 ringgit, with the exception of plantation industry and domestic maids, where the employer is responsible.
My name is Sabra Seth. We will explain the next point, which is temporary disablement benefit. This benefit is paid for up to 4 days of medical leave, including the day of injury as determined by a doctor. On the other hand, it will not be paid for days when the employee works and receives pay. Hence, it is calculated at 80% of employee average anticipated daily salary. The minimum daily charge is 30 ringgit and the maximum daily cost is 105 ringgit and 33 cents. We move to the next protection is payment of wages. Indonesian workers were also protected regarding the payment of wages under Section 19 of Employment Act. Under this act, all employers must pay each of their employees not later than the 7th day after the last day of any wage period, which shall be deemed to be 1 month if no wage period. It defined in the contract of Section 18 subsection 2 of the Employment Act, which stated, if in any contract of service no wage period is specified, the wage period shall for the purpose of the contract be deemed to be 1 month. Last but not least, we move to the next protection is working hours under Section 60A of Employment Act. Indonesian workers cannot work for more than 5 hours consecutively without a minimum rest time for 30 minutes. They also cannot work for more than 8 hours per day, more than 48 hours per week, and also in excess of a spread over a period of 10 hours in a day. The workers who is engaged in work that must be done continuously and requires his constant attendance may be compelled to work for 8 hours in a row, including a time or period of not less than 45 minutes in total, during which he will have the opportunity to eat. That's all from me, thank you.
In this situation, Siva and Haris may approach the Department of Industrial Relations and make representations to the Director General of Industrial Relations for the unfair dismissal of their employment. Representations must be filed within 60 days of the dismissal, as stated under Section 20, subsection 1A of the Industrial Relations Act 1967. Upon receipt of the presentation, the Industrial Relations Department shall arrange a conciliation meeting between the employee and the employer. An officer from the department shall act as a mediator in the hope that the matter can be resolved without going to court. If the parties reach a settlement at the meeting, the matter will end there. But in situations where the parties cannot reach a settlement at the meeting, the matter will be referred to the Industrial Court. The Director General will refer the matter straight to the Industrial Court if the Director General is satisfied that there is no likelihood of a conciliation settlement. If the court finds that the termination was without just cause or excuse, the dismissal will be held as unfair or wrongful. Siva and Haris can ask the court to order reinstatement to their former position in the company or compensation of 1 month's salary for every year of their employment and back wages maximum of 24 months that Siva and Haris would have earned if they were not dismissed. Other than the remedies available under the Industrial Relations Act, Siva and Haris may also file a civil lawsuit against Mr. Bala.